Okay, I'm on page 100. I'm starting with more unprotected speech. And again, all of this comes through court cases. Somebody sues, and then there's an argument on whether or not they can be sued or if it's protected speech. Or the government makes a law restricting speech and somebody sues, and it's determined whether it's protected speech. So far right now, all speech is protected until otherwise. And in this class, we've talked about obscenity, or I've been reading about obscenity, not protected. Now we're going to go over some other not protected speech as it stands now. The future, new court cases are coming out, more conversation is happening. We'll see what happens. So we're going to start with libel and slander. Another type of expression not protected by the First Amendment is defamation. False statements that are malicious and may damage a person's reputation. Libel refers to written, slander to spoken. You remember slander as SS, slander spoken. Libel is the written, but it's defamation. And just giving an opinion is not defamation. Defamation has to be lying about someone. And the lies can't be positive lies that help them. It has to hurt, damage reputation. And when they say reputation, usually it has to do with like their job. If you lie about someone and it hurts their chances of their livelihood, there's a good defamation case. I would argue if you're lying about me, which I one of the ones I tell students that if you're saying that I don't cover the material for a test, I would argue that's defamation. I'm more than willing to cover all material for my classes, and I have students ask questions, and it's all I can show where all the material is that is covered by the test. You are factually telling an untruth, and you're trying to hurt my reputation as a teacher. Now, if you say I'm an awful teacher, that's an opinion. That's not defamation. That's freedom of speech. Opinion is different than defamation. Okay, so of course, if politicians could collect damages for every untrue thing said about them, the right to criticize the government, which the court termed the central meaning of the First Amendment, would be stifled. No one would dare be critical for fear of making a factual error. To encourage public debate, the Supreme Court has held in cases such as New York Times v. Sullivan that statements about public figures are libelous only if made with malice and reckless disregard for the truth. Public figures have to prove to a jury, in effect, that whoever wrote or said untrue statements about them knew that the statements were untrue and intended to harm them. This standard makes libel cases difficult for public figures to win because it is difficult to prove that a publication was intentionally malicious. That's why gossip magazines, and now I guess it's mostly online, can pretty much publish any secondhand, third-hand, fourth-hand, made-up idea that they want about a celebrity because it's pretty hard to sue libel in the U.S. So celebrities will go to England. It's easier to prove a libel case as a celebrity in like an actor or singer in England than it is the United States. But it's really also much more so about politicians, because politicians in power can use the government to abuse their opponents. And we need to, and I will stand by this with any of you, protect that. Protect the ability to criticize politicians. Another issue too to bring up, and hopefully I'll remember in class, is slap lawsuits, where you sue even though when you know you're going to lose, but you're trying to bleed them of money and put fear in others. We'll talk about that later. That's a new, I don't know how new, but it's being talked about more in the media I read about, well, okay, I know I'm not going to win a defamation case, but I'm going to sue you anyway. Hope you have a good lawyer, and I hope you have money to pay for it. Talk about that later. To win libel lawsuits, private individuals have a lower standard to meet than public figures do. They need to show only that statements about them are defamatory, falsehoods, and that those who made the statements were negligent. Nevertheless, it is unusual for someone to pursue a libel case. Most people do not wish to draw attention to critical statements about themselves. There's actually, for celebrities, it's called the Streisand effect. Look it up. Streisand as in Barbara Streisand, where you by bringing attention, now people know about it. Whereas if you just not said anything, it would have died out on its own. It's an entertaining idea. Google it. If public debate is not free, there can be no democracy. Yet, in the process of free debate, some reputations will be damaged, sometimes unfairly. Libel cases must thus balance freedom of expression with respect for individual reputations. In one widely publicized case, General Westmoreland, once the commander of American troops in the South Vietnam, sued CBS over a documentary it broadcast called The Uncounted Enemy. It claimed that American military leaders in Vietnam, including Westmoreland, systematically lied to Washington to make it appear that the U.S. was winning the war. The evidence, including CBS's own internal memoranda, show that the documentary made errors of fact. Westmoreland sued CBS for libel. Ultimately, the power of the press, in this case a sloppy, arrogant press, prevailed. Fearing defeat at the trial, Westmoreland settled for a mild apology from CBS. If CBS and News wants to get it right, then they would do it without it being a lawsuit. It has to be a goal, and this is why I'm an advocate of mainstream media, is that their reputations matter. Just because someone says they don't like mainstream media doesn't mean they're not. The mainstream media, whatever that means, isn't telling the truth. And one of the issues is you should care about your reputation. I don't know enough about this case to actually say anything about it. But it should matter. And do know that you have to be vigilant that just because something's in print or on TV or worse on YouTube, you have to go look for other evidence of it if you think it might be true. This is where conspiracy theories are running rampant. Although that might be an exaggeration on my part. I shouldn't say that. An unusual case that explored the line between parody and libel came before the court in '88 when Reverend Jerry Falwell sued Hustler magazine. Hustler had printed a parody of a Campari liquor ad about various celebrities called First Time, in which celebrities related the first time they drank Campari. The phrase first time had an intentional double meaning. When Hustler depicted Falwell having had his first time in an outhouse with his mother, Falwell sued. He alleged that the ad subjected him to great emotional distress and mental anguish. The case tested the limits to which a publication could go to parody or lampoon a public figure. The court ruled that they can go pretty far. All 9 justices ruled in favor of the magazine. There's actually a movie about this, and no, I am not showing it. The idea was nobody actually believed it was literal. They understood. Anyone looking at this cartoon would understand that it was just mocking him, and it was meant to be mocking him, and it was negative, and intentionally so negative, but it couldn't be taken literal in its protected speech. Okay, symbolic speech. Freedom of speech, broadly interpreted, and is a guarantee of freedom of expression. In 1965, school authorities in Des Moines, Iowa, suspended Mary Beth Tinker, who, by the way, is still alive and gives speeches about this issue, and her brother John, not sure about him, when they wore black armbands to school to protest the Vietnam War. The court held that the suspension violated the Tinker's First Amendment rights. The right to freedom of speech, said the court, went beyond the spoken word. As discussed in Chapter 2, when Johnson set a flag on fire in 1984, Republican National Convention in Dallas to protest nuclear weapons, the court decided that the state law prohibiting flag desecration violated the First Amendment. Burning the flag, the court said, and this is Texas v. Johnson, constituted symbolic speech and not just dramatic action. So with flag burning, you got to be careful, though, because it can still be labeled as some kind of arson. If you go on private property, and set fire to something, you can get in trouble for another reason. But I would fight for anybody that you have a right to burn the flag. People get offended. Offense, just like with hate speech, just because people are offended doesn't mean it's not protected speech. With the Tinkers case, what's key here is it was argued they were not disruptive. If you come into school with political speech, I would defend that. If you come into school with political speech and start screaming at people or making a ruckus about it, you are not going to win that. It cannot violate other people's rights to an education. And that was what was key to Tinker. They were not disruptive, as long as not disruptive to others. Education, whatever that means. I mean, it does mean something. I shouldn't say it so glibly. When Massachusetts courts ordered the organizers of the annual St. Patrick's Day parade to include the Irish American gay, lesbian, and bisexual group of Boston, the court declared that a parade is a form of protected speech, and thus that the organizers are free to include or exclude whomever they want. And since 2015, it's not really an issue anymore. Back in the day, much more an issue. So, for example, if you have a gay pride parade, they don't have to allow in anti-gay protesters. That doesn't mean they can't show up. They just can't be part of the parade because that's protected speech and of their issue. Now, if it's a government parade, let's say the government's organizing it, I don't know how that works. You might have more of an argument there because the government can't pick and choose. But I'd have to wait for a court case to see how that actually played out. I can only guess until then. Wearing an armband, burning a flag, and marching in a parade are examples of symbolic speech. Actions that do not consist of speaking or writing, but that express an opinion. Court decisions have classified these activities somewhere between pure speech and pure action. The doctrine of symbolic speech is not precise. For example, although burning a flag is protected speech, burning a draft card is not. I believe it's because draft cards were argued and successfully argued that draft cards are government property, so it's not yours to burn. In 2003, the court held that states may make it a crime to burn a cross with a purpose to intimidate, as long as the law clearly gives prosecutors the burden of proving that the act was intended as a threat and not as a form of symbolic expression. Especially if you burn a cross in someone else's yard. In 2015, the court upheld Texas's refusal to allow specialty license plates bearing the Confederate battle flag because the speech was government rather than individual speech. Despite the imprecisions, these cases make it clear that First Amendment rights are not limited by a rigid definition of what constitutes speech. So, with the Confederate flag, which is technically, yes, the Confederate battle flag, the Texas license plate is government speech. It's not yours. You can put a Confederate flag sticker on your car because it's yours, but that license plate can be controlled by the state. But that's the ruling they made then. Hopefully you're figuring out rulings change. Like, you might not agree with some of these rulings, and you have that right. You aren't gonna, win, but maybe you could put a court case out, different justices, times change, and you never know. We watch the court to get the guidance on what we consider protected speech or not. And moving on from that, let's go to free press and fair trials. The Bill of Rights is an inexhaustible source of potential conflicts among different types of freedoms. One is the conflict between the right of the press to print what it wants and the right to a fair trial. The quantity of press coverage given to the trial of Michael Jackson on charges of child sexual abuse was extraordinary, and little of it was sympathetic to Jackson. Defense attorneys argue that such publicity can inflame the community and potential jurors against defendants and compromise the fairness of a trial. It very well may. Nevertheless, the court has never upheld a restriction on the press in the interest of a fair trial. The constitutional guarantee of freedom of the press entitles journalists to cover every trial. When a Nebraska judge issued a gag order, any kind of gag order says you can't talk. You can't talk about this. There might be a gag order on a defendant, on a plaintiff. You can't talk about the case. When a Nebraska judge issued a gag order forbidding the press to report any details of particularly gory murder, or even to report the gag order itself, that it was under it, the outraged Nebraska Press Association took the case to the Supreme Court. The court sided with the editors and revoked the gag order. In 1980, the court reversed a Virginia judge's order to close a murder trial to the public and the press. The trial of a criminal case, said the court, must be open to the public. So it might sound really rough if you want your trial to be private, but you have a right. The idea of the bill is it being open, being public, having press access. The goal is actually to protect the defendant, because then it's open and the public can be aware of what the government's doing, and therefore the government would be on its best behavior. Of course, now it can backfire, and not just now. Historically, I mean, they had newspapers and stuff before how our mass media works today. It can backfire against someone, because no one, it might be hard to get a jury that's impartial. A pretrial hearing, though, is a different matter. In a 1979 case, the court permitted a closed hearing on the grounds that pretrial publicity might compromise the defendant's right to fairness. I would also say grand juries, when grand juries look at evidence to see if there's enough for a trial, which is part of pretrial, those are often, we don't know about them until they come out with their determination on whether or not someone should be prosecuted. Ultimately, the only feasible measure that the judicial system can take against the influence of publicity in high-profile cases is to sequester the jury, thereby isolating from the media and public opinion. So put them in a hotel and don't let them watch TV or talk to people about the case. Occasionally, a reporter withholds some critical evidence that either the prosecution or the defense wants in a criminal case, information that may be essential for a fair trial. Reporters argue that protecting their sources should exempt them from revealing notes from confidential informants. Some states have passed shield laws to protect reporters in these situations. In most states, however, reporters have no more rights than other citizens once a case has come to trial. The court ruled in Brandsburg v. Hayes that in the absence of a shield law, the right to a fair trial preempts the reporter's right to protect his or her sources. After a violent confrontation with student protesters in Stanford, the police got a search warrant and marched off to the Stanford Daily for photographs of the scene they could use to make arrests. The paper argued that its files were protected by the First Amendment, but the decision in Zurcher v. Stanford Daily sided with the police. Shield laws might be better, are usually a little better when you use anonymous sources for whistleblowing. So you want to share what's going on with the government, but you don't want to be known because of retribution. And the police, the newspapers would argue, or any media, that they have protection to not share their source because it's whistleblowing against the government. Commercial speech. I'm going to stop on this one and start up on the next one for that.